Phyllis and her husband had a rule that they encouraged, which means they told John to go to be an engineer first. So at first he did a degree in engineering, then he went to law school, and then he did an LLM in tax. And he has for decades now been one of the most important people in Phyllis Schlafly's work. And he continues that today for our organization. And I just would like to point out, because we're so excited and we can't miss an opportunity to brag on this, when Phyllis Schlafly picked Donald Trump in 2015, 2016, and endorsed him, she had a vision for what he could be as a president in terms of the regulatory environment, in terms of law, in terms of judges, and she was right. And Donald Trump admitted, and so did his team, that she was one of the most important people in that process because she gave him credibility with conservatives, and it made a huge difference. All these years later, we see that she was right. But I want to point out that for the last 10 years of her life, she would not have been as effective. She would not have been remotely as effective, except that John was her right hand and allowed her to continue to raise her voice and to be effective and really change the course of American history, and I would argue the world. So John is also the treasurer of our Eagle Forum Educational Legal Defense Fund. He's a great foil if you need someone to tease. I encourage you to use him that way. He's available for banquets and home events at any time. So John, you're supposed to have come up by now. You're supposed to be up here by now. John Schlafly to give us some reflections on Phyllis. Thanks, John.
Well, thank you, Ed, and I'm struggling with this. My friend Maureen Blum, who's here, said that there's a new part of getting ready to go out these days, and that's having the right mask that goes with your outfit. So I have solved that problem by just standardizing with one color, as you can see. Well, my role here is just to give a few personal reflections about, the founder of this group, Phyllis Schlafly, and how she got interested in patents. Her father had a career with Westinghouse, which was founded by one of the great inventors in American history, and which had a culture of invention in its organization. And when he lost that job during the Great Depression, and my mother was a young girl. She watched as her father kept his sense of reality by working on his own invention during that very, very difficult time, eventually patenting his invention. And although it was not commercialized, was nevertheless a very great achievement because it's the incentive of the patent which is so valuable. And so then, and then when she was a young mother in the 1950s, raising a big family, she reflected on the fact that she didn't have to work as hard keeping house as her mother and grandmother did, and that was in part because of inventions, labor-saving inventions which removed the burden of women, which persisted throughout most of the human history, but has been relieved from American women then, and even more so now. And so she began writing about patents and inventions. I found an article from 1970, which was an award-winning article. And then in 1987, which was the year of the 200th anniversary of our United States Constitution, and when the Chief Justice of the United States, who realized that his own 80th birthday coincided with the 200th anniversary of our Constitution, he resigned from the Supreme Court to chair a commission to commemorate the bicentennial of the Constitution. Phyllis Schlafly was on that commission, and she took as her particular task to promote the importance of the only provision of the Constitution that contains the word right, and to talk about how important that was. And then she became aware in the 90s about attacks on the rights of inventors, and there was a flurry of proposed legislation in the 1990s that she fought vigorously, including the effort to publish inventions before the patent was issued. That was a horrible thing. And then again, a decade later, in the 2000 to 2013 period, where there is an effort to institute post-grant review, which was another horrible thing. And so she fought those attacks on the rights of inventors and continued to champion the cause of the individual inventor against the interests of the multinational corporations who are, seek to undermine the economic rights, including the right to exclude others from commercial exploitation. And so you might have noticed there was a gap in that history that I mentioned, and that was kind of the best-known period of her life in the 1970s, when she was busy, in her view, saving our Constitution from an unwise amendment. And my friend Phil Kiko here, who's recently watched the horrible TV show about that episode, asked me what I thought about it. And but then she returned when that episode was over. But she did believe in the uniqueness of the patent provision of our Constitution, unique in human history. It was the first time that had happened. The framers of our Constitution in Philadelphia apparently adjourned their deliberations to go look at a steamboat, and they decided that that was something that would help to develop America. And the patent system in America is unlike that of any other in the world. And when in the 1990s there was an effort by multinational corporations to harmonize the American system with that of the European system or the world intellectual property system or what they had in Japan or China, Phyllis Schlafly said, why should we harmonize with them? Let them harmonize with us. We have the best system. We have 90% of the great inventions that have ever been invented. Let them harmonize with our system. And she continued to champion the cause by telling, many of the great stories of the great, and she would tell stories of the well-known inventors of the 19th and early 20th century who became household names like Whitney and McCormick and, of course, Edison and Bell and all of those people. And, just one last thing, Abraham Lincoln, as many of you know, was the only president who had a patent. His patent was never commercialized, but as Lincoln said in a pretty eloquent statement, which is chiseled on the wall, I believe, at the Department of Commerce, and you can see it at the heading the Twitter feed for Secretary Wilbur Ross, where Lincoln said, the patent system added the fuel of interest to the fire of genius. And so those of us here who understand that the patent system creates, in effect, a patent owner owns a small business that is created by his invention for limited times, and long enough for him to start an enterprise and build a business with it. And that's what it's all about, and that's what Phyllis supported, and that's what our organization continues to support, and we welcome all of you who share in that vision for our constitutional patent system. So thank you all for being here tonight.
Okay, everyone, we're going to start the program. Feel free to keep eating, but I'm going to now introduce Kimberly Chakowski. Am I doing it wrong, Kimberly? Sorry. Vice President and Head of Licensing Strategy and Operations at InterDigital, to introduce our speaker. Thank you to her and InterDigital for their support and great work. So, Kim, please.
So again, good evening. It's great to be here. And I have the distinct honor of introducing Assistant Attorney General for the Antitrust Division of the United States Department of Justice, Makan Delrahim. Makan has held a lot of positions that are extremely very impressive through not only private practice and governmental, but somewhat similar to my earlier discussion that he missed of my wonderful song renditions, I did a little research, and there are a couple things that really struck out to me. And one of them was something that I then took a little bit further look, and some remarks that Makan had made during a naturalization ceremony in Washington, D.C. in 2018. He credits his work where he pumped gas, changed oil, tuned up cars, and sold tires as experiences that taught him a lot more than just to work on a car. This resonated with me because as a child I had a mowing service that I called Ms. Mowers. And it also taught me some of those similar hardworking principles that carry over, and we can obviously see those hardworking principles are carried over today. He goes on to say that this taught him the hard work of the American entrepreneurial spirit, resilience, and dedication. The other thing that really was interesting to me was his work and his op-ed in the New York, I guess it's the Wall Street Journal, no, New York Post, discussing the importance of the future Supreme Court nominations. And we find ourselves today in that similar type of position, so I'd love to hear what your thoughts are on that sometime. But Makan is the ultimate champion of the free market and the protector of the consumer. He continually positively impacts and shapes antitrust policy, and for that we are quite grateful. One of the things I also mentioned earlier today, and I'll reiterate in your presence, is the fact that the relationship that you have with not only fostered with the DOJ and the USPTO and NIST has been something that has been a really incredible positive for the United States and especially for the intellectual property. And we thank you for that contribution and that cohesiveness. And having been at LES and InterDigital, we've had the opportunity to have all of you as speakers throughout, and it's been an honor to now be the one that's presenting you. So without further ado, I'd like to present the Assistant Attorney General for the Antitrust in the United States Department of Justice, Makan Delrahim.
Well, thank you so much, Kim, for the introduction. I got to say, it's a hell of a lot better than the introduction I got last week at this event we held jointly with the Patent and Trademark Office. My friend, Director Iancu, who many of you know, he and I share a lot of viewpoints on these issues of importance. And he introduced me and he said, I'm sure for many of you who've never heard Makan speak, you're looking forward to what he has to say. And, you know, and many of them had that same reaction. I hope to, you know, tonight, I had some prepared remarks, and I looked at them earlier today, and I said, for my first actual in-person gathering in, 8-9 months, I ripped them up. I said it'll be a hell of a lot less fun. I've got some notes that I'm going to use to highlight some of the work that we have done at the division that you guys might care about, but I thought we could make this more of a conversation. Feel free to interrupt as I mention some cases or some initiatives, as long as you don't call me a clown, a fool, and don't tell me to shut up, man. A liar, too. Other than Sheldon Whitehouse, nobody else has called me a liar in my life. But we'll see how it is. But thank you again for having me. There's a number of issues that I think we share in common philosophically, dealing with intellectual property. My old partner, Phil Kiko, when he was the chief of staff to the House Judiciary Committee and Chairman Sensenbrenner, and I had a similar role in the Senate Judiciary Committee. We actually did a lot of good together. We worked well. We advanced, I think, both copyright law and patent law, and it's great to see him here, and it's great to see him still the Chief Administrative Officer of the House of Representatives. On the IP issues, I grew up, I became, when I was an undergrad, I studied physiology, and I loved patent law. Why? I don't know. I was reading in the papers back then a big fight between a new startup in the United States that grew up in my hometown. It was started by a company's name was Amgen, and in Thousand Oaks, California. And they were in the press with a huge patent fight with a company from Japan called Chugai Pharmaceuticals, dealing with patents over certain cell lines that were transferred. And that was a big part of their major blockbuster drug. I think they were just a tiny little startup then, but the patent fight was all over the press. And that was something I was following in the news, and I said, this is what I want to do for a career. So I came to Washington to go to law school, like most patent lawyers back then did at GW, because nobody else used to teach that stuff. And I worked at the NIH, and I thought, this is what I want to do. And then I realized that this whole licensing side and the transaction, and that was a heck of a lot more fun. And so I became a licensing, and then from there became an antitrust lawyer. Just right at the time when litigation over patents and patent, trolls and other things was just exploding. So I went completely from the most lucrative part of the law, got out, and started doing antitrust in probably the least lucrative part of the law, especially post the Bork Revolution. And so based on that, you got to take what I say with a little grain of salt, that I might not be the smartest man in the room. But ingenuity and entrepreneurship are just fundamental to our free market system. When inventors and entrepreneurs compete to make the best mousetrap, we all win. The consumer wins because they're getting the better mousetrap. Usually the previous mousetrap will be a hell of a lot cheaper. So you're getting that dynamic competition. That business will hire folks, and you've got all sorts of all the other positive benefits that come from that. Our forefathers, enshrined the patent laws and the rules for the road in the Constitution. They knew that the right to control the invention was a key part to actually creating the incentives to create it in the first place. Antitrust law that I gravitated to is also fascinating. It's the same, it's the other side of the same coin, that both contribute to a competitive environment to foster greater and more innovation. Some people in the 70s viewed patents with a lot of skepticism. They used the antitrust laws to try to address and control the market power that intellectual property created. There was these famous DOJ rules called the 9 no-nos. These were licensing rules of exercising your patent rights that were illegal back then. And fortunately, with the Chicago School, and frankly, back then, Judge Bork's work on the importance of the proper analysis of antitrust laws with neutral principles, very much what he did about constitutional law, he did in antitrust law, about a 40-year-old piece of work called the Antitrust Paradox, which is something that I understand is going back into print and was a key discipline. But there were a lot of things. I'm just going to give you one example. If you invented, we have some inventors here in the room as well, but let's just say you are a printer company and you've invented the great next new printer, and you want to exploit the printing technology and get the better, faster, neater printer to the consumer. But that technology might have application in medical imaging. But that's not the business you're in. You make printers. You don't want to get into the medical imaging business. So you would license that patent, get some royalties in to create, MRI machines, and you give that to GE or Philips. But you say you cannot make printers. That's my business. That's what I invented. But you can go make all the MRI machines using my technology that you want. These were one of the no-nos under the antitrust laws before 1979 or so, called a field of use restriction. The idea was, by you telling the licensee not to make printers, you are now controlling the printer market share and gaining your market power in that. Well, what do you think is going to happen with that computer printer technology company who has this wonderful new technology? Do you think he's going to say, well, okay, well, in that case, I'm going to turn over the licensed technology for the new printer mousetrap to GE and let them destroy my business? No. Here's what they would have done. And this was the practice. They just refused to license it for all these other beneficial uses. You know, maybe that technology could be used in geospatial mapping and somebody else could use it. But what we realized with economic thinking in the Chicago School is that that's a pretty asinine way of treating innovation policy and antitrust law, because you're actually hurting the consumer. You're hurting that patient who might be the beneficiary of the better MRI machine from that technology rather than doing that. So those practices started to change. And over time, more and more, including even just more recently at the Supreme Court with some time. Some people frown on the power of patents, and they use the antitrust laws to try to limit the market power that a patent confers. I do not understand how people still hold those views if you understand some of the basics of economics and exclusive rights, but that's kind of unfortunately where we are. Some antitrust lawyers, view every patent as a tool for market power that they must now control, as the hammer that needs to hit that proverbial nail. I was in China maybe 15 years ago when they were drafting their antitrust law for the first time. They implemented the anti-monopoly law and created their antitrust agencies in 2008. It was August 8th, 2008, for the first time. So, 12 years ago. But in 2004, 5, 6, I made about 5 or 6 trips to help them draft their law, try to do as little damage as possible. Successful in some ways. But one, I remember we were in Shanghai, and the principal drafter of their law got up and said, if you own a patent and you do not license your patent to your competitor, you're going to be violating, and license it reasonably, whatever that meant. You are violating the antitrust laws. And they said, the reason is that patent, you have market power. And if you have market power, you have monopoly power, and therefore. And I got up, and I had recently been put on some statins. And I think it was Lipitor at the time. And I said, let me just give you guys an example. Lipitor, back then, it was under patent. Fortunately for many of us, it's a generic now. But I said, Lipitor that I take is under patent. You have Mevacor. You have Crestor. You have, at the time, there were 5 of them. I think there's 9 different ones on the market. Each one of them has a patent as a new chemical entity. None of them, from a competitive standpoint, has market power. You know why? Because they're substitutes. That's how antitrust law evaluates these now, unlike the old days, because your doctor can prescribe a competitor. So you cannot look. Now, it's true that it could be a patent that confers monopoly power in a market because there are no other substitutes to it, but you cannot look at intellectual property with this discrimination in order to treat it as market power for antitrust. They're like, and then after dinner with our, certainly I didn't have broken Mandarin, but they had they spoke much better English than I spoke Mandarin. We had further discussions, and fortunately they did make some changes in the law, but in a most basic way, that's how people think about it intuitively. It is this negative reaction. So one of the first things I did, and just this weekend I celebrated, if there's a celebration, of the 3rd year of my Senate confirmation, and thank you, and being sworn in. Thank you. I haven't been fired yet, and I haven't had a scandal, but it's been a privilege being in that job. But one of the first things I did, I think it was that October at USC, and then later at University of Pennsylvania, I gave a speech about the new Madison approach. And we wanted to rethink and completely shift the way that the Antitrust Division and the Federal Trade Commission and others, and our international partners, think about the way we deal with patents, specifically with patents that are part of a standard. And a standard, whether it's in communications or, electronics, it could be in biotech, but it's when a number of inventors get together and they come up with a standardized feature, which we have found to be a positive thing. Again, patent pools and standard setting had been no-nos in the 70s, but we found that you actually reduce friction and create a lot of efficiencies when you do that. Imagine if you had multiple electric outlets and they weren't standardized for all of our power to be put in. So there's some positives. But as we have seen more recently, there's a number of standards that pop up and people use technology in them, and the technology competes by the body, and you have you select a technology, and whether or not it reads on a patent is an interesting debate. But a lot of the patent owners will commit to that standard setting body to license their patents later if it's adopted as part of the standard on what's called fair, reasonable, and non-discriminatory. These are contractual obligations you make to the other members of the standard body. Some scholars at Berkeley and others, came up with a theory that if you have a patent as part of a standard, that somehow you have now a certain market power, and you do have some market power, but that if you violate a fair, reasonable, non-discriminatory term, then that is a violation of the antitrust laws. It is intuitively, it has some appeal to some people, and some courts certainly adopted that view. To me, it was antithetical to our constitutional system and respect for intellectual property laws, and particularly the exclusionary element of intellectual property laws. If you couldn't exclude others from exercising your rights, whether it's a copyright or a patent, what the heck do you have? So if antitrust laws come in and force that, where Congress has provided you with injunctive relief, how are you ever going to be able to compete with an incumbent? So I view that as pro-competitive, pro-consumer of a stance as you can have. So I gave this speech called the New Madison Approach, with basically had 4 pillars. Fortunately, it's traveled well, including at the UK Supreme Court within the last month, and the German Supreme Court, and a bunch of courts in the United States that have adopted it. First, the holdup, which means that, somebody not licensing their patent, but, hasn't negotiated it, itself, because of a violation of a FRAND commitment, is not an antitrust injury. It is rather a violation of a contract. So was your license reasonable? Well, who knows? What's a reasonable royalty? That's what you have courts and juries find in a patent infringement, and that's your contractual violation. I said I'm going to license this reasonably. You're telling me that my 5%, 6%, 10%, 20% is not reasonable. Well, it doesn't convert to an antitrust violation because it's a violation of a contractual commitment. So the remedy should be in contract, or it could be in fraud if somehow there was some kind of a fraudulent intent and concealment. Those are the proper ones. I'm going to be one of those first few Washington enforcers or regulators who doesn't want that power, that thinks it's not good for America to have that kind of power in antitrust. And so because there's a whole debate of where's the leverage. If I cannot, if it becomes an antitrust violation, and we'll get into kind of the injunctive relief and who has the power, as the inventor, if you can freely infringe your patent and then try to litigate over 5 years, do you really have the resources to be able to do that and not be able to exclude? So that in and of itself is not. Second, the standard development organization, when parties get together to develop a standard, should not become a body for implementers of the technology to collude together in order to hurt the innovators. And that type of collusion is what Justice Scalia called in a Supreme Court case the supreme evil of antitrust law. That is the type of conduct that we worry about, we should be worried about, was when horizontal competitors come together, and what they do is they create a monopsony effect, which means the inventor is not getting rewarded properly, but is getting below market rates because they can't enter into the buyers because they've all made a pact saying that we're not going to buy unless you sell to us at a lower rate. That's an important concept that we thought that was important to get out there. Third was the fundamental right to exclude is to have injunctive relief. You can't, courts should not disfavor injunctive relief just because your patent is part of a standard. That's, injunctive relief is injunctive relief until Congress somehow changes the law. Congress could come in and say, look, if your patent is part of a standard, you don't have the benefit of injunctive relief. If you can do that, that's such is life. But that is not what has happened, and it would be, I think, unwise for Congress to do that because then you've taken away the most important fundamental pillar of an intellectual property, right? And lastly, as part of the new Madison approach, is the fact that if you don't if a unilateral, that means you have not agreed with your competitor, if you have unilaterally refused to license your patent, it shall be per se legal. There is no antitrust liability. If you just refuse, you want to sit on it, you could sit on it all you want. It's a short period of time. That is the social contract that we have made. Now, I guess presumably you can say it's so important we need it to cure cancer and all that, but fortunately our forefathers were a lot smarter than us. They created the takings clause so government could come in and reward properly if it's that important as in an eminent domain, presumably. But otherwise, antitrust law should not come in and say, you know what, you must license it. If you don't, you can't. So that was an important part. The previous administration in 2013, the DOJ Antitrust Division and the Patent and Trademark Office put in a policy statement which began to get adopted at ITC and in the courts that looked disfavorably upon injunctive relief. December of 2018, at Stanford, I announced our unilateral withdrawal of that policy statement, said we're not going to follow that. It's been misinterpreted. It took a year, but I was proud that last December, Andre Iancu at the PTO and I and Walt Copon at NIST signed a new policy statement where we actually respect the injunctive relief for patent holders in a standard essential patent. Thank you. We also said that, there, in addition to a possible holdup, you might actually have holdout by implementers, by licensees and users of patent, and that's an issue you have to look at as well. So our program, I think, is not only constitutionally sound, but as a matter of innovation policy, the right approach, and it has changed a number of things. The other thing in this area as a matter of policy that we have changed that I'm particularly proud of is that I created and have been criticized by some on the House Judiciary Committee, this thing called the amicus program, where we are entering into district court and courts of appeals and the Supreme Court, where we do, but in private cases. We will file as a matter of our right to ensure the antitrust laws are properly applied. We are entering into court. We're presenting oral arguments. I think in the last 18 months, we had filed 29 amicus briefs. I think the previous 5 years, we had filed 10 altogether. But we have had a pretty darn good track record where we have entered. It's never been on one side or the other. We say, look, there's 5 of these issues. These are 3 issues you should not find. And we have really, I think, turned the ship on the development of antitrust law in the courts, particularly in the area where it intersects with patent law. We filed just this February in the Continental versus Avanci, which is a patent pooling arrangement dealing with 3G and 4G technologies, a statement of interest that dealt with the FRAND-related issues and the limits of it. We advanced the new Madison approach in that. And earlier just this month, in September, the court agreed with us and dismissed the complaint with prejudice, holding that, quote, it is not anti-competitive for a patent holder to violate its FRAND obligation. And it explained it disagreed with, quote, those cases concluding that deception of a standard-setting organization constitutes the type of anti-competitive conduct required to support a Section 2 claim. That's a Section 2 of the Sherman Act. We made a similar filing in Lenovo versus Interdigital in July in the District of Delaware. Lenovo went even further than Continental had. It argued that initial agreement to be included in a standard violated the antitrust laws provisions on anti-competitive contracts. The motion to dismiss is still pending, but I'm hoping that our reasoning there, and I believe it's Judge Stark, if I'm not mistaken, who's a brilliant young judge appointed by President Obama, but an incredibly reasonable judge who I think will take favorably, hopefully, with our views. We filed in another case, Intel versus Fortress, and the judge agreed with us in our analysis and dismissed the complaint. Again, this was a complaint brought by Apple against and Intel against Fortress, saying that just the acquisition of patents in this broad market of electronics market patents is a violation of the antitrust laws, and we said that just doesn't sound in proper antitrust market definition. And then all of these cases involve the inappropriate application of antitrust law that are being decided in the shadow of the Ninth Circuit's decision in FTC versus Qualcomm. That's a fascinating case. I think the panel decision, I did not participate in it. Our friends at the FTC, 3 days before inauguration in the Obama administration, you talk about midnight regulations, which the statute, Congressional Review Act allows to address for abuses on the way out. I don't know if Congress has done anything about midnight litigation, but 3 days, this was after the election, 3 days before inauguration, 2 of 3 commissioners of the FTC voted over the strong objection of the sole Republican commissioner to file a case, and because of a 2-2 tie, because of a recusal, the staff of the FTC, in direct contravention of the executive branch's policy position, has continued to litigate that to the Ninth Circuit, and most recently they appealed for an en banc hearing. There's an academic part of me would love to see the Supreme Court, especially this Supreme Court, see and hear that case, but it's at a major cost to inventors and others, which is a shame, but such is life. We also, for the first time in the Fifth Circuit, filed a case jointly with the Patent and Trademark Office on an issue dealing with what the royalty rate should be. Rather than the market, rather than the inventor deciding what that rate should be, the plaintiffs in that case, in HTC versus Ericsson, had said that it should be based on the smallest, if it's under a patent as a standard, the royalty shall be based on the smallest saleable practicing unit. Now, where does that come from? Is that in a congressional statute? Is that in the Patent Act in 35 USC, or is that in the Antitrust Code? No, it's not. It's some brilliant academic, probably got paid tens of millions of dollars to come up with that theory, which is wonderful. But you know what? It's not the law. We advanced that in the Fifth Circuit, and that same issue was accepted in Sisvel versus Heyer in the German Federal Court of Justice, and they took our side of the issue. We did not participate in that, but hopefully the Fifth Circuit will say no. You know, you let the free market decide of a price, especially when it's involved in a patent. Kind of, you know, reminds me of that old joke when the bear bellies up to this bar and comes up, and everybody is shocked. He lays down a $10 bill at the bar and says, "I want a beer." The bartender is freaking out. "What the hell is this bear doing here? We've never seen a bear here." Runs in the back to the owner and say, "Hey, there's a bear who wants a beer. What should I do?" He's like, "What? A bear?" Looks through the door and sees a bear sitting there. He says, "Does he have any money?" He goes, "Yeah, he laid a $10 beer, $10 on the counter for a beer." He goes, "All right, give him a beer." Bartender runs back, gives him a beer, and the bear is gulping it down. And he's looking at the bartender. He's like, "Why are you looking at me?" He goes, "You know, we've never seen a bear coming in here." And the bear goes, "Well, at $10 a beer, I bet not." And so you got to let the market do price discovery. That's the moral of that story. So let me end with a little personal story. I joined from private practice the Senate Judiciary staff to work on patent-related issues at the time, and worked for Orrin Hatch. And I remember Ms. Schlafly was quite active on patent reform issues, and there was a particular provision dealing with prior user rights of inventors and whether or not, you know, if somebody was practicing that patent but that had not been public, they could continue to do that. She was, I believe, very close friends with Senator Shelby's wife, Mrs. Shelby, and so Senator Shelby had said that he would not clear the bill until we met with Mrs. Schlafly, who came in to see Senator Hatch. And it was fascinating. So it was, I mean, to me, to meet an absolute icon and, you know, who has created the Eagle Forum and all of that. So it was fantastic. And it was around that time, I think Dr. Ogilvy might have been, some of you may know him, but he was the chaplain of the Senate. And Bill, do you remember Dr. Ogilvy? Oh, yeah. The Reverend? Phenomenal man, and he was there my first time, you know, walking into the Senate. I remember the very first thing was, this whole thing is just this small, and very first time you walk on the Senate floor. And then Dr. Ogilvy was back in the Republican cloakroom, and I'd just seen it. He'd just looked out to the Senate, and he'd done his prayer, and I said, "Dr. Ogilvy, I'm Jewish." I said, "You pray for the senators when you do that?" And he said, "Makan, no. I look out at those senators and I pray for the country." That was not a true story, by the way. Not to get me in trouble with Dr. Ogilvy, but sometimes you look at the Senate confirmation process that has really broken down, and for an incredibly bright and incredibly gifted and qualified new nominee like Judge Barrett being there. And you just hope that the Senate does the right thing to somebody willing to step up and be a real role model on the Supreme Court, and be a role model in the same mold, maybe different, some people would, as Mrs. Schlafly. And so I hope that we won't be watching the confirmation process and praying for the country too much, but we can only hold out hope. Thank you again for having me here. I'd be happy to take any questions. Nobody interrupted me, but I'd be happy to. I'm surprised because Bill usually does.
There's mics on the side, or pass them around so that people, or maybe you don't want to pass them around. So
Yeah.
we have a recording of it. Whatever you think, Bill.
Got it.
Bill hasn't been sick in days.
Another one right. A little fever.
Yeah, exactly.
14 days.
Hey, we just want to thank you, Makan. I mean, you've just been doing incredible work. I mean, all of these things which they might not grab the headlines, but they're so important, like that BRL letter and whatnot. I mean, it's just top to bottom. And the fact that you get, I didn't realize, actually I had forgotten. I knew Makan when he was chief counsel on the Senate Judiciary Committee. I didn't know you had such a strong background way back that far in patents. So it's fantastic. It shows, and I want to laud you.
Thank you so much. Thanks, Bill. Thank you.
Thank you.
I've bought many of your products. I just hope you got some license royalties out of that. But
Thank you for helping with the legal deals. This might be a rhetorical question because I don't know if you can comment, but we really appreciate the way the DOJ is advocating in the antitrust area for property rights. Elsewhere, the DOJ is advocating that patents are not property rights, that the Fifth Amendment doesn't apply, that the Seventh Amendment doesn't apply. It seems to me like you're representing the administration and our historic patent system. There's a disconnect in other parts of the DOJ, and there's a lot of continuity from the past administration to this administration on the nature of patents when these issues are challenged. So I'm talking about oil states, I'm talking about Fifth Amendment takings challenges, I'm talking about appointments clause challenges, I'm talking about basic right to a jury trial. I don't know if you can comment on that, but we sure would like an advocate on those areas like we have on antitrust.
well, thanks. You know, the only thing I could really say about some of those, and some of those kind of happened, they were already baked in to the process. For example, you know, whether or not patents are a property right or a public right. You know, so whether it's in the Supreme Court and the Solicitor General has a say, and multiple folks who have an interest in it write to the SG, Antitrust does, the Civil Division does, PTO does, and other folks. So sometimes they have to factor in multiple considerations as they formulate a position for the administration. And they come to it from different viewpoints at times. Fortunately, I think our current Attorney General is a strong advocate of property rights and the proper application of the antitrust laws that is principled. So hopefully if any issues come up now, they are being handled in the way to respect the constitutional standing of intellectual property rights. And I'm pleased there's a case going up to the court next week, which I'm looking forward to, dealing with copyright. But it's Google versus Oracle. And that's a seminal intellectual property case. And I believe the administration's position in that is very sound.
Just one point of clarification. A lot of those issues have been baked and decided. On the Fifth Amendment, the current position of the DOJ is that on the Fifth Amendment, the takings question is that if the patent office invalidates your patent, it means that you never had a patent. Therefore, nothing was taken. Therefore, no compensation is owed. That's the position that's been advocated most recently by the DOJ.
Other questions? There's mics over there. John, you must have a question. You always have questions. Get up there.
Well, Mr. Sec, your comments about free enterprise are certainly welcome, and consumer welfare, and that's all very familiar to many of us who've studied that field. But the United States today, it seems, is more and more in competition with the Chinese Communist Party, with enterprises that are owned by or controlled by the Chinese Communist Party, enterprises that are designated as national champions of China. That's not free enterprise. And how do you view these concepts of free enterprise and antitrust when the party on the other side is controlled or owned by the Chinese Communist Party?
So, great question. And I think an issue that this administration, through the Trade Rep's office, through the Treasury Department and the Committee on Foreign Investments in the United States, and some of the changes Congress has made to that, has been addressing. But it's an important one, because how do we look at, if we're looking at a international market as opposed to a U.S. or local market? So we address a number of these issues, and a lot of times, you know, trade remedies are factored in to how we determine, you know, for a merger. You bring a broader issue of important, I think, public policy import here, and it's one that dovetails to yet another one that is related, which is China 2035. China 2035 is something I recently spoke about, and I've spoken to Ambassador Lighthizer about. It is a active, deliberate program by the Chinese Communist Party to enter standard-setting bodies and control them, whether through their governance or through funding of technology by the state in order to be adopted in standards. And it's not just communications, it's communications, biotechnology, artificial intelligence, and we are looking at a deliberative effort that we have begun to really take a look at and address. Most recently at the Leadership IP Institute speech on the day that we had announced a revision of a IEEE Business Review letter, which touched on some of these issues, I said that we need to take a look at whether or not the technologies and the members of a standard-setting body are state-owned or state-controlled. And that is something that we need to be much more vigilant about. In our area of antitrust, that's one way to address it. Of course, there's trade laws and national security provisions in our domestic laws that need to be vigilant. And fortunately, I think the last 3 years, you've seen a major uptick in how those are evaluated.
Other questions or comments? All right, we'll stay up there for 1 second if you don't mind. I'm going to give you an award. So thank you very much. I have to say, if I can give you your boss credit, a lot of things that in this period of time we're talking about, some of them make sense, some of them don't, like the debate last night and all that. But the president did a heck of a job of hiring good people like you to do really smart work and to not, to manage the direction he wants and then to let you do great things. And I think it's a real credit to him and to you. So thank you for being here. It's very, yep. All right. Congressman Massie, if you'll come up here. We're going to give 2 very special awards tonight, and I want to, after I get done reading a little bit about each of them and the award, I'd ask Rebecca Gantner, our executive director, and John Schlafly and Jim to come up and make sure we get photos with everybody. But we've been doing this for a few years now and building the momentum, I think, to make this important arguments about policy, about politics, how they fit together. Phyllis taught us to make sure that we understood the policy and then understood how to make the politics work and make the system work because that's how you make real progress. And this award, which is called the Phyllis Schlafly Friend of American Invention Award. And with this award, the Eagle Forum Educational Legal Defense Fund, we recognize leadership in strengthening the U.S. patent system and protecting inventors. And a recipient will have sought to advance the exclusive right of inventors to their inventions for the patent term. Recipients will have demonstrated leadership by advocating and working for reliable, enforceable patents. They'll stand up for inventors' freedom to exercise patent exclusivity and to reap the fruits of their inventive labor. Recipients reflect these principles, the commitment and the leadership on behalf of patents and inventors that Phyllis Schlafly displayed over many years as a leader in the conservative movement and as a member of the Bicentennial Commission of the Constitution. Many of her writings, I hope you've seen that book outside, Phyllis Schlafly Speaks on Patents and Inventions. We were very proud of having compiled that. I mentioned at our table, Phyllis was, of the many gifts she had, one of them was being an extraordinary, prolific writer, and she did that from the time she was in her teens until the weekend she passed away. She was working with her son John on her last column, which was published 2 days after she died. So this is the spirit, this is the reason that we started the Phyllis Schlafly Friend of American Invention Award, and these 2 men in particular, we see that spirit in their work, in the way they think and talk about these issues, and the way they address their public life. So let me first say Congressman Tom Massie, who's been a great friend on this issue for a long time, and has many more patents than Abraham Lincoln ever could dream of. And he represents Kentucky's 4th Congressional District. He's an inventor himself. He has 30 patents. That's 30 times the power of Abraham Lincoln. And he earned his bachelor's and master's degree in engineering from MIT. There he was awarded the Lemelson MIT Student Prize, and he invented a technology at MIT that enables touch interaction with computers. His startup, Sensible Technologies, raised over $32 million in venture capital, created 70 jobs, and obtained 24 patents. The hardware and software he developed and are now used to design automobiles, jewelry, shoes, dental prosthetics, and reconstructive implants for wounded soldiers. When he got to Congress, Congressman Massie is the go-to authority. His colleagues agree that go-to authority, they don't always agree with him, but the go-to authority for many of his colleagues on understanding these issues. He's played an extremely influential role. He's really been a leader ahead of his years in a body that often rewards service by years rather than by experience or even intelligence. And he's played that extreme influential role, including the defeat in 2015, as most of you know in this room, of the mislabeled Innovation Act. And he also is the author of the Restoring America's Leadership in Innovation Act. That's Congressman Tom Massie, and now for a brief, a little bio on Assistant Attorney General Makan Delrahim. He's the first patent attorney, I don't know if you knew this, to head the Antitrust Division, and his legal and policy work has been at this intersection of antitrust and intellectual property. We heard that today, and it's really inspiring to know how much thinking he's doing on this topic. He served on the Attorney General's Task Force for Intellectual Property, and from his executive branch, congressional, and private law practice, he has developed and articulated a sophisticated yet elegant framework at this important nexus and for these areas of law. His new Madison approach, which you heard about, which I hope you'll read the longer speeches about that, is setting a constructive approach to antitrust enforcement where IP rights are being exercised. I have to say, Yanku needs to stay for another 4 years, and so do you. So I don't know what you guys could probably all be judges, but don't do that till the end. His approach has been validated recently when the Ninth Circuit Court of Appeals found for Qualcomm in its appeal of the FTC's antitrust case, which is a big deal. The Antitrust Division under him has expressed its interest along the same lines in several other cases, which we've talked about. It's my pleasure, and we're so honored to have this award that we created and to continue this going forward in such a way and to lift these men, in this case men, but these people up as people that we not only respect, but we express our gratitude towards for this leadership. So John and Rebecca and Jim, come up here so we can give these awards. John, you can do some heavy lifting over here. I know you were resting, but so congratulations to you both, and thank you for being with us today. So here we go. And here's our photographer over here. Where should we go? Okay. Move away from the mic. Bossy, the photographer. Let's go in front of the mic.
Would you like us?
Go up here. You guys go up in front of the podium. Here we go. Get in the middle.
All right, I'll go.
Here. Oh, good. Everybody look. Oh, we're looking at the congressman first?
No, I don't care about y'all.
Okay.
That's what I thought about Congress. All set? Oh, one more picture here. Is that your guy? Okay. Now you two guys get to make a comment.
All right.
Acceptance speech. Short one, 5 minutes.
Oh, 5 minutes?
No, I'm just
Okay.
kidding.
All right.
Minute,
Thank
1 minute. Sorry, 1 minute. You can do that.
Well, first I want to give a shout out to Tim Burchett here. He and I sort of have a dinner club, and it was my night to buy, so I invited him to this patent event.
Smart guy. Smart guy.
We're both.
Couldn't get in University of Tennessee, though.
First, I want to thank you all for braving the virus and coming here tonight. I'm not an epidemiologist. I'm not an immunologist, but I can do differential equations, and we are approaching herd immunity. And I'm sorry if you don't like that word, population immunity, whatever, but we're getting there. If you look at the data, you don't have to be an immunologist to see where we're going when you look at the equations. But I do thank you for braving the virus, because I've got the antibodies, and not everybody does. And our governor is a Democrat, and he's had some of these horrible edicts in Kentucky, things that we're supposed to comply with. But my daughter's getting married Saturday. Wow. And the only edict that I've been, thank you. The only edict that I've been happy to comply with is the 50-person limit on weddings. The governor, our Democratic governor, he's almost a conservative. He saved me $20,000 at least. Bill Wichterman said that he doesn't believe that we're the result of random acts, and I agree with him. I believe we have a creator. We were designed. This planet was designed. This universe was designed. But there's no other way to describe Congress but through random acts, okay? So I got to explain the random act for how I ended up here, or a little bit of how I ended up here. I grew up a hillbilly, still am one at heart, but I read about a place called MIT, and I wanted to go there. So I built robot arms in junior high and then high school, and I applied. I didn't even get to visit the campus, but I got accepted, and I showed up the week for class, the week before class. Moved into my dorm, but the day I got there, I was crossing Mass Ave. There's one stoplight in the middle of the campus, which is good. There's only one road going through the campus because most of the nerds are not paying attention. And I wasn't paying attention either, but a car honked at me. The first day, I was in Cambridge, Massachusetts, and I was like, can you believe that? I've been here 4 hours and already run into somebody from Kentucky. So I would start waving back at the car. They were waving back with one finger. They wanted me out of the crosswalk. And I went there for science and engineering. That's my passion, obviously. But you had to take humanities classes. So I realized I could take economics classes and I wouldn't have to write papers. I could do problem sets instead. So the first one I took was microeconomics, and I fell in love with microeconomics. Here's the science that helps you explain how people behave, which is good for nerds to try to understand how people behave. But then I took macro, and my instructor was Paul Krugman. No. Yes. And he talked about this mythical place called the Chicago School, which is why I know me and Makan can be friends, because he associates himself with the Chicago School, but Paul Krugman did not. So anyways, a little bit about patents. They're so important, and they're fundamental in the Constitution. To tie it back to antitrust, there are a lot of conservatives wringing their hands about big tech now, and they have a monopoly on social media and a monopoly on our devices and a monopoly on our information. And how would we ever bust that monopoly? Surely we need more government. We need more government to get in there and do it. But that's antithetical to our conservative principles. But the original antitrust clause in the Constitution is the patent clause, because it's what allows the little guy to break up the big guys through natural competition. And the big guys can't steal your idea. So when I talk to other conservatives in Congress who are wringing their hands, what do we do about big tech? Make patents stronger, because that will enable the little guys to come up with the better version of what they make. So I'm a big believer in patents. I do some invention on my farm, in fact. I got to tell you real quickly about an invention I'm working on. This will be my 31st patent. It's a automated chicken tractor. Okay, my kids have moved out of the house, and somebody has to raise the chickens when I'm not there. So it's like a Roomba with chickens in it, and it moves to a fresh piece of grass every day. So the chickens, their poop doesn't accumulate. They get to eat grass and bugs. It's how a hippie would raise chickens. And so anyways, I built this thing, and it's solar powered, and it collects water, so you don't worry, I've already filed the patent, so I'm not making a disclosure. And it collects water so you don't have to carry the water to it. But my first version, which I ran last summer, had a lead acid battery in it. And I thought, this is not very green to have a lead acid battery, even if it lasts 3 years. How much lead would you trade for a dozen chicken eggs, right? It's just not clean. So I figured out how to do it with a capacitor. So there's a super capacitor in this now, and I call it the Klux capacitor. The way I met a lot of you in this room is on H.R. 9. I was sort of in the wilderness, and I didn't know most of you in this room, or in the case of Jim Edwards, in a different context, not through patents. And the day before Thanksgiving break, they passed H.R. 9 out of committee. That was the Innovation Act. Everything is named the opposite of what it actually does here, right? Like the CARES Act, I call it the Don't CARES Act, because we're spending all of our grandkids' money and we don't care. So the Innovation Act was going to hamper innovation. And without talking to any of you I saw this, Shauna, by the way, my staffer here on IP, my legislative director, she's been with me since day one. If they ever want to get me out of Congress, they just get Shauna to leave and I will quit. But she sent me a message. They're like, they just passed this H.R. 9 and I think you should take a look at it. I don't think you're going to like it. And it wasn't on my radar. And I said, well, when are they going to bring it to the floor? And she says, the day after we get back from Thanksgiving. And I said, when can we get amendments in? She says, noon on Monday after Thanksgiving break. And so I looked at the bill and I thought, what's the worst part of this bill? Well, they were going to affect the injunctive relief. There were 8 sections in it. There was a customer stay provision. And they were going to make it harder to get injunctive relief. And it said, I don't have much time. This is the worst part of the bill. And Shauna wrote an amendment to strike Section 5, which would have, if the bill had passed, it would have made it harder to get injunctive relief. I identified that as the worst part of the bill. And that's how a lot of us came together. But we didn't defeat H.R. 9. They had too much momentum, but they didn't have time to pass it in the Senate. And then next year when they brought it up, we had the momentum on our side because we had inventors like Josh, and we got the universities on our side and the venture capitalists, and people started waking up to what a terrible tragedy that this would be for our country. But that battle is not over. That battle will be going on every Congress and every administration. There's going to be a battle for patent rights. And so I want to close with this because I know you told me to speak 5 or 1 minute, whatever. You get this question a lot when you're an elected, politician. Will the next generation be the first generation whose quality of life goes down? Because for all of mankind, for all of human history, every generation has been better off than the last generation. Is the next one going to be worse? And I say, well, if you rely on Congress, that's almost a certainty, okay? But if you understand that inventors prevail and that we are standing on the inventors from the previous generation, and we don't forget the ideas. We patent them. That's the social contract, right? We don't hide them away in a box and have a secret sauce. Well, maybe in Kentucky with fried chicken we do. But for everybody else, you've got this social contract. Well, I will show you everything. Every little thing down to the serial number and the dimensions on the bearings in exchange for just a small period of time to redeem my investment, to recoup my investment. And so that's the social contract. So what I tell people is, if you're relying on politicians to make the next generation better, you're screwed, okay? But if you realize that it's inventors and entrepreneurs and the capitalists who have improved our lives for every generation, as long as we keep Congress from screwing up the rules, as long as we keep it a fair playing field, we're obviously going to be better in the next generation. Next year will be better than this year. I don't care what virus attacks us, because inventors will overcome any problem that there is, and that's why I support all the inventors. Thank you.
Thank you again, and what a special night. We're really, Assistant Attorney General, you honor us with your presence, and thank you to Director Young, who was it last year, Jim, or the year before when he came? We get these all-star speakers, and we build the momentum that is so important to us. Thank you again to our sponsors. You'll see these all over, and we'll continue to thank you and use opportunities to highlight them. Acacia Research Group, Bio, IEEE USA Intellectual Ventures, Interdigital, Pharma, and U.S. Inventor. We're just very grateful. Again, we keep doing this work. We hope we can be a resource for all of you in the work you're doing. Our office, as you may know, is just off of the Capitol behind the Supreme Court. If you ever need the space, we'd love to do that, and Jim will always help us make that available. Thank you again to Jim, Rebecca for such a great job. Peter Harder, who's not with us, who does a lot to help us. We really appreciate Peter's leadership, and John Schlafly for being with us. We had a wonderful evening. We'll look forward to it. We have a tape of it, and we'll make sure to make that available to you also as we go forward. And thanks again. Have a great night, everybody, and we look forward to seeing you again next year. Thank you.